Welcome to the Appeals Court. I'm Justice Mead. With me today are Justices Henry and Singh. We'll be the panel for this case. As you know, Zoom being what it is, sometimes we have screw-ups and follow-ups, and if that occurs, we will do our best to reestablish contact with you, and no one will be deducted anytime. Each side gets 15 minutes. Understand the department and child's lawyer are splitting their time. And with that, I'll call the case as 21P 405, Department of Children and Families versus Father. And of course, you all know that this is impounded. Ms. Healy.
Thank you, Your Honor. Good morning. May it please the court, my name is Julia Healy, and I represent the appellant father in this matter. In this case, Your Honors, there were two petitions before the child court. One was a permanent custody petition under Chapter 119, Section 26, and there was a guardianship petition under Chapter 190B, Section 5206. The trial court erred in treating those petitions as if there was a termination of parental rights trial in front of the court. The court erred by acting as if there were competing plans under a termination of parental rights trial, one being adoption by the foster parent, and the other one being guardianship. It's clear that the trial court did this through conclusions of law 33, 34, and 4. In conclusion of law 33, the trial court clearly says the process employed by the court was when a parent offers a competing plan from those proposed by DCF, and the court must assess the alternatives and choose the plan. And conclusion of law 4 says here is an adoption of DOR, father advocated a completing plan of permanent guardianship, and where parents offer a competing plan, the judge must assess the alternatives. Conclusion of law 4, the court found that it was in the child's best interest to remain in his current foster home. That clearly was not an issue before the court. In front of the court was simply the 11926 petition as to whether or not the parent, and I'll say father, mother's not a party to the appeal, whether or not father was currently unfit, and if father were to be found currently unfit, and we are not contesting unfitness. So once the court found unfitness, the court's decision was simply to put the child, whether or not to put the child in the permanent custody of the department or make another appropriate order that felt it was in the child's best interest. Under the guardianship petition, the court's job was to consider if the welfare or best interest of the child would be served by the guardianship. And if it were, the court must, and the statute uses the word must make the guardianship appointment. The court erred by not weighing either of those standards, using the standard in a termination of parental rights trial of the competing plans, and under adoption of Reed, the decrees simply are not binding because the court used the improper standard. Had the court used the proper standard to determine the guardianship petition, the uncontested evidence would have shown that the guardianship was clearly in the child's best interest, and the court would have needed to appoint the guardianship. The court would have considered the uncontested evidence that the child lived full-time with these grandparents. And when he lived full-time, they ensured he was safe, they were bonded. There was no evidence of concern at all regarding the grandparents' care, and the child had no needs or issues while he was in the care of the grandparents. Those needs and issues did not arise until he was with this foster parent for 7 months. Once DCF removed this child, the grandparents were involved with him. DCF didn't offer visitation until I believe 9 months after they removed the child. But even before that, the grandparents went to visitation with father, and they visited the child at the bridge home, which we can talk about in a minute. However, the grandparents also had a loving home. They were going to be able to support him, to take him places. The grandmother did not work outside the home. The grandfather planned to cut his hours to be more with the child. They said they would take any courses or do any orders, do anything the court wanted them to do to take care of this child.
Counsel, you say that the error was treating the plans like competing plans. And yes, I understand you're saying that each petition should have been independently reviewed, but as a matter of practicalities, there were competing plans.
No, Your Honor, with due respect, they were not competing plans. In a competing plans case, in a termination case, the state is no longer going to be involved in this child's life. There are competing permanent plans. And the term permanent custody is very misleading. because this was a permanent custody trial, but under a permanent custody trial, once permanent custody is given to the department, the parents have the right to come back every 6 months and advocate that they are then fit and should have custody of their child. In a competing plans case, in a termination of parental rights case, the state is ending its involvement. So usually DCF has a plan of adoption normally, and a parent or a child has a plan of, let's say, guardianship. But that is an end game. So the DCF's plan for adoption would be adoption by this foster parent. That puts the foster parent front and center. That makes the foster parent incredibly relevant to the analysis. But in this case, there was no end game. The foster parent was not ever going to adopt this child. And the court made that clear, and DCF and the child agreed to that in their briefs. This was not a termination case. The foster parent was not an adoptive parent. So the court, weighing the foster parent in its analysis of the 11926 or the guardianship petition, was clear error. And that is the difference. That's why they weren't competing plan cases.
So what were the considerations that the judge took that they shouldn't have?
Regarding the foster parent, there's legal and I'm sorry.
With respect to the guardianship petition, in denying the guardianship petition.
So in denying the guardianship petition, Your Honor, the court was viewing it as a competing plan to adoption by this foster parent. So it was weighing the foster parent with the guardian, with the grandparents. And that was the error. And the findings of fact are riddled with findings regarding the foster parent. I've read you the conclusions of law. Clearly the court weighed this foster parent. I don't think that's in consideration. I think that's pretty evident. So the error was, instead of determining what is in this child's best interest, permanent custody to the department or guardianship by the foster parent. And in that way, I'm not going to use the words competing plans because that is a term reserved for these termination trials. But those were the two issues in front of the court. I agree with that, Your Honor. The two issues in front of the court were, is permanent custody in the best interest of this child, or is a guardianship in the best interest of this child? But the error was the court taking this foster parent, about whom it made many, many, many findings, yet refused to allow to be called as a witness, which is another issue, but was taking this foster parent and saying, okay, I'm literally going to weigh foster parent here, grandparent here, and put them on a scale. That was the error, because the foster parent isn't relevant to permanent custody.
If the foster parent, if you take out the foster parent involvement, the factors that the judge used in order to deny the guardianship petition, was there anything wrong about the factors used by the judge or the reasoning used by the judge to deny the petition?
Yes, Your Honor. There were many things that were wrong. First of all, as I've already said, the court ignored all of the uncontested evidence about the grandparents' ability to parent this child, that there were no needs while the child was in their care, that the grandmother was not working outside the home, that she was available, that they stayed in contact with this child. There was some things about the visits where the grandparent wasn't able to visit for a little bit of time because the mother was threatening her, and also because it was just too difficult for her. But by and large, these were active parents. Even 9 months, in the 9-month gap that DCF wouldn't allow them to visit, they still managed to remain active. The court also erred in finding that the grandparents would be unable.
The department and the child are arguing that if you just look at the guardian petition by itself, the grandparents were in denial about domestic violence between the parents and its impact on the child and the child's needs, and that they couldn't protect the child from those things. So what do you say to that?
I would say, Your Honor, that those findings are simply not proved by a fair preponderance of the evidence. If you look at the uncontested evidence, there is no evidence that before the removal, the grandparents knew about the domestic violence or allowed. What we have to remember is the grandparents took this child in because the parents were not able to care for the child, right? At the very beginning of this case, the parents were going out and doing whatever they were doing, and the grandparents came to the rescue and said, I'm going to take this child part-time. Wait, I need to take this child full-time, because these parents just can't do it. So number one, there was evidence of that, and there were no concerns while this child was in their care. There were no needs while this child was in his care. There's also evidence that the parents simply did not know the amount of domestic violence that was going on. And if you look at Dimitri, a panel of this court found in Dimitri in a case exactly on point with this one, where there were no diagnosed needs when the child was with the grandparents, there were no concerns regarding care with the grandparents, and DCF never offered the grandparent services. A panel of this court said a question necessarily emerges whether the deficit of the grandparent's ability to parent is attributable to DCF's failure to allow the grandparent to learn about the child's needs and participate in the services. So for the court to find that it is the grandparents' fault that they did not know about something is in clear error under Dimitri. I would also add that the grandparents couldn't have, it's not like they turned their back and should have known. There was no incidence of domestic violence in front of the grandfather. There were two in front of grandmother, one where father hit mother and one where father slapped mother, which is not, which is not good. And obviously that's why the grandparents took this child in. But neither of those were in front of the child. One of them was in front of a half-sister, at which point the grandmother removed the half-sister from a stroller and brought her into a home. So the only evidence we have about these grandparents is that they protect the children. And they also protect themselves when the grandmother was in an abusive relationship years before trial, I think 20 or 30, 20 maybe years before trial. She got a restraining order and left. So these are not people who allow themselves or others to be abused. The fact that there was a history of domestic violence between the parents, that the grandparents did not know about, that is attributed to the fault of DCF, not to the fault of the grandparents. The court also erred in not considering the fact that DCF violated its mandate to keep families together by offering them needs and services under GL 18B, Section 3A. That we as a Commonwealth, under care and protection of 3 minors, have a policy to keep children with natural family wherever possible. And the court ignored that mandate as well. And the court erred in not considering DCF's failure to use its mandate to encourage resources by any family member to strengthen and encourage family life. DCF not only didn't tell these grandparents what was going on and help them with services, but they actively worked against them. When the grandparents needed a letter to get a bigger apartment so that they could have the child, and DCF said, oh, that's great, you have a 2-bedroom apartment, we'll consider you. They refused to write the letter for the housing authority to help the grandparents. I believe the social worker testified that the grandparents in DCF's mind was out from day one. So the court erred in denying the guardianship petition by not weighing the fact that these faults, quote unquote, that DCF kept talking about the grandparents, weren't faults of the grandparents at all, but were the fault of DCF by not educating them and helping them in ways that they were going above and beyond to help and educate this foster parent who was not seeking custody. The grandparent, DCF knew the grandparents had a legal petition in court to seek custody of this child. They refused to help the grandparents in violation of legal mandates and this court's rulings, but yet gave this foster parent who had a 51A filed against her, who was told twice by the social worker that she needed to change her parenting skills, who, when the child was suicidal at age 2.5, threw up her hands and said, I'm not handling this, I'm not doing this. And they were forced to put the child in another placement. DCF gave her service after service after service, but refused to, and the only reason that's relevant, because the foster parent really isn't relevant, is it shows DCF's failure to help this kinship placement and the court's error in not considering the court's failure to help this kinship placement.
Was it wrong for the judge to have considered the entire history of the grandparents, their personal history, their history together, to consider all of that? I mean, you're focusing on the window of time that the child was with the grandparents. But was it wrong for the judge to have considered their personal history, which is significant?
It was error under Stewart and many other cases for the court to only consider the negative evidence presented against the grandparents and not to consider the uncontested positive evidence. For example, the court found that this grandfather had this criminal history. Well, yes, in a vacuum, the grandfather had a criminal history, but the court failed to consider the uncontested evidence that for the past 19 years, and that's a long time, for the past 19 years, the only thing on grandfather's criminal history was a motor vehicle infraction. So that was error. You have to evenly weigh the evidence. You can't pick and choose the evidence that you like and ignore the evidence that you don't like. The court talked about domestic violence between the grandparents. Well, when you look at the police report that was in evidence, the police put it as a verbal dispute on the police report. They did not see injuries on the grandmother. The grandmother said it was a verbal dispute. Nobody was arrested. And at trial, the grandmother said she couldn't even remember it. So it was error not to consider that uncontested evidence and only to consider, the negative evidence against the grandparents. I see my time is running short. If there are no further questions, I will rest on my brief. Thank you, Your Honors.
Seeing none, thank you. Ms. Murphy.
Good morning. May it please the court, Lynn Murphy for the Department of Children and Families. The only issue before this court is did the trial court abuse its discretion in failing to grant the guardianship petition? The court did consider all the evidence and found that the grandparents were just not suitable and that the child's best interests were not served by placement with the grandparents. I think that the evidence overwhelmingly showed a history of chaotic behavior, criminal behavior. The grandmother struggled taking care of her own children, and this carried on into the time of trial. The father continued to live with the grandmother. The mother continued to have problems with the grandmother. In fact, during one period of time, the grandmother couldn't visit with the child because she was having altercations or verbal altercations with the mother. So there was
counsel. I take it you disagree with the father's counsel, and you think that the grandparents did not meet the requirements of the guardianship statute. Is that right?
Yes, I believe the court clear findings and conclusions show that they were not suitable, and it would not serve the child's best interests to be placed there. We have a child who has a tremendous special needs. And we also see from the record that these parents continue to engage in domestic violence. And we have paternal grandparents who don't recognize that fact. This child has had to have extensive trauma therapy and has PTSD. And if the guardianship was granted, there was a very high likelihood that the child would be re-exposed to domestic violence. Again, these behaviors didn't end. They continued right up until the time of trial. Father and mother were still engaged in physical altercations, and the grandmother on the stand refused to acknowledge that domestic violence was an issue, even though she observed these behaviors.
So counsel, given your detailed arguments about unfitness, why wasn't the department seeking to terminate parental rights? In other words, was this a legal strategy so the court didn't have to consider the department's plan against the guardianship option?
Well, I think it was a variety of factors. When we filed when the trial was underway, that was in 2019, and unfortunately, COVID intervened. So by the time the trial concluded, the department in fact realized that we should have moved forward on a termination and will in fact be doing so very shortly. But at that point, it was too late to change gears at that point, and it wouldn't have been fair to mother and father at that point. But the department, both children are in a pre-adoptive home, the same home they've been in, or this particular child and his half sister have been in this same family the entire time. And the department
was that a factual? I thought that the foster parent was an adoptive option.
Yes, that's right.
So you disagree with the father's counsel on that point?
The foster mother, the record shows the foster mother is a pre-adoptive placement for the child, and she remains a pre-adoptive placement to this day. And the department will be moving to terminate in a separate proceeding. Well, if there are no further questions, I will rest on my brief and ask you to affirm the trial court's findings in this case.
Thank you. Attorney Fisher-Nair.
Yes, good afternoon. My name is Julia Fisher-Nair, and I represent the appellee child in this matter. Your Honors, today this court's decision-making really has to do with whether the trial court has abused its discretion. I'm going to agree with my sister on this. And ultimately, the father's arguments amount to nothing else but dissatisfaction with what the trial court did in its discretionary decision-making. However, the record shows, and the trial court's findings clearly support the fact that in this particular case, the trial court's findings were extensive, and they supported the ultimate decisions that the trial court came to. The father does not contest that he is unfit. The father simply is dissatisfied with the way the court approached the evidence that was before it. Father says that the trial court was erred because it had to award the guardianship to the paternal grandparents because of the standards under statute 5206, the guardianship statute. However, the bulk of the statute focuses on the best interest of the child, which is, once again, a discretionary matter. The evidence was contested. It was not uncontested as to the paternal grandparents. And in fact, the trial court was very extensive in pointing out all of the evidence about the paternal grandparents, both positive and negative. However, the evidence that was contested shows multiple examples of why my client, who, by the way, is in an ultimate kinship placement right now, because as the trial record showed, he is placed with his sibling and continues to be placed with his sibling and is very happy. But multiple examples of how these potential guardians, the paternal grandparents, although also kinship, but were not suited, were not in the best interest for my client. They had minimal knowledge of my client's special needs that were outlined extensively, both through testimony of DCF employees and through documentary evidence that was entered into exhibits. The grandparents did minimal to invest into supporting their relationship with my client throughout the time this case was pending. Even during the time that the trial was actually going on, the paternal grandparents failed to visit with my client, to have any kind of connection with him. Criminal history, yes. Father's attorney does correctly point out that it was 19 years prior to the trial beginning, but the types of crimes that the paternal grandfather had in his history really were relevant and for the judge to consider. The trial court, there were crimes to do with substance abuse and violence. And in fact, that was also connected to the court's findings that the paternal grandfather had very minimal experience in raising young children or children with special needs because of his criminal history. The grandparents were not truthful or did not disclose what was going on in their backgrounds with mental health and criminal history and domestic violence to their own experts that the father hired during trial. The investigation or the evaluation that their experts engaged in was not comprehensive. And once again, that was also discretionary on the trial court's part to summarize whether that expert was successful or not, and was within discretion when it concluded that unfortunately the expert testified herself. She did not have all of the information she should have in order to render a complete and comprehensive opinion about the grandparents' potential suitability to care for my client. Paternal grandfather's mental health was not disclosed on. He had significant history of suicide attempts and also involuntary hospitalization that the expert didn't know about. He was under care of a mental health professional. He didn't even know himself by his own testimony whether that was a psychiatrist or psychologist, and couldn't even talk about that. Domestic violence, that was really the center of this case. And there's been multiple examples of how domestic violence affected my client. And Your Honor's bottom line is, this case is nothing but father's dissatisfaction with the discretionary decision-making by the trial court that acted within its power. There was no error. And we ask you to uphold the trial court's, the trial court's orders and decisions, and in denying the guardianship to the paternal grandparents. Thank you.
Thank you. Thank you all. We'll take this under advisement.